Wonderful, thank you, and welcome to our last ACELG lecture. Last ACELG lecture of the year. We're delighted to have Laurent Pech with us. Professor Laurent Pech is a full professor of law and dean of the Sutherland School of Law at UCD, University College Dublin. He is also a visiting professor in Bordeaux and senior research fellow at Central European University Institute. Central European University Democracy Institute. Also co-director and founder of the Good Lobby Profs, which is something I'm sure also our students may be interested in. And he has worked as legal consultant in many EU candidate countries, including Bulgaria, Latvia, Montenegro, and Bosnia and Herzegovina. Professor Pech specializes in EU public law and is one of the leading voices on debates on rule of law backsliding in Europe, on which he has published many books and articles. Some of his other research interests include judicial independence and comparative free speech law. And I should say his interest in the rule of law also extends to practice, and you contribute with several expert advice before European courts. Today, you will present insights from your recent working paper with the CEU Democracy Institute by the title, The Use, Misuse, and Non-Use of the EU's Rule of Law Toolbox, which was attached to the conference, to the lecture website. Thanks again, Laurent. We're delighted to have you here. You will speak for around 30-35 minutes, and then we'll have a discussion. Thank you.
Thank you very much. And thank you for having me. This is my first time at Amsterdam School of Law. It's a pleasure to be with you. I'm actually no longer a dean. I'm on research leave, which is very nice, but don't worry, it was not a mistake because I'm supposed to act as dean again next September. So, plus once dean, always a dean, apparently. That was not a mistake at all. And thank you essentially for giving me the chance to kind of let you know about my latest paper on the EU's Rule of Law Toolbox. I'm going to give you an overview, a flavor rather of the paper, which is very long, but the beauty of publishing working papers is, first of all, you don't have to worry about the length. And then also, if you make any mistake, it can be corrected prior to publication. The paper is very long, but I had a lot to say. I've been working on the different tools of what is now the toolbox for many years. In fact, I used to work on the rule of law before it became cool to do so. I've started working actually on practical rule of law issues during the course of my PhD. One of my PhD supervisors was appointed judge at the Constitutional Court of Bosnia. And long story short, then that led to kind of a rule of law related job. And I didn't even know at the time that you could actually make a living working as a rule of law consultant. I knew about the concept itself, not that it could actually lead to well-paid consultancy jobs. Back then, it was actually not very trendy to work on rule of law, to the extent that the assumption is that the rule of law was only an issue for outside of the EU, for mostly it was of interest to non-EU countries and especially EU candidate countries. And this is why actually I worked in a rule of law capacity in many candidate countries. But then after working on rather technical, if not dull rule of law issues, by the time Orban was re-elected in 2010, then I started focusing more and more on the internal rule of law dimension. And since then, actually, I have given up almost completely on the external dimension of the rule of law because problems have not stopped accumulating. And essentially, this is why I'm going to tell you about EU internal rule of law tools. So I'm not going to mention at all the external dimension. That would be, in fact, the topic for another presentation possibly. To make it easier for those of you who have not spent much time worrying or focusing on the toolbox, I have divided the presentation into three main parts. I'm going to give you a flavor of the so-called prevention/monitoring rule of law tools. Then I'm going to switch to response tools. And then I'm going to bring it all together. And then I'm going to tell you about the transversal trends I have essentially detailed in my working paper. And then I will conclude with a rather depressing prediction about what to expect in the next 5 to 10 years in terms of the next phase of the rule of law in the EU. You don't have to agree, obviously. Perhaps you can make a more optimistic assessment of the situation, but to be discussed, I'd be happy to answer many questions for as long as we have. So when it comes to the EU's toolbox, what you're looking at here on the slide is not my table, my overview of the situation. This is from the official, essentially overview of the toolbox adopted by the Commission. So this is the latest version, and the European Commission has divided or distinguished between promotion, prevention tools, and response tools. This is not a perfect overview. I mean, I can think of missing tools, but essentially I'm not here to redesign this overview myself. But in terms of missing tool, for instance, you have the Council's annual rule of law dialogue, which is not mentioned on this slide. My understanding is the Commission has only provided an overview of the tools the Commission does control, and then has left beside the tools in which the Commission is not involved or marginally involved. And today I'm going to tell you briefly about the annual rule of law cycle, the European semester. I'll tell you also about the rule of law milestones. And I'm going to tell you briefly about the cooperation and verification mechanism, which was ended in 2023. And then I'll switch to response tools. And I have selected examples showing, at least from my point of view, the non-use or the misuse mostly of those tools. So we're going to begin with the rule of law report, which is one of the latest prevention tools. This is essentially the monitoring tool per excellence in the toolbox now. This is the flagship of the toolbox according to the Commission. This was launched by the Commission in 2020. It's the so-called annual rule of law cycle. And then every year you get 27 reports about the 27 member states, then a transversal report. And then most recently, EU candidate countries have also been included into this cycle, 4 candidate countries so far. This is a permanent monitoring mechanism, so supposedly dedicated to examining the situation in each of the member states. To be fair to the Commission, before I start criticizing this instrument, the Commission didn't want it initially. That's something people have forgotten. It was rather imposed from on the Commission by candidates to the presidency of the European Commission. So politicians wanted to do something about the rule of law, and their key idea was, why don't we adopt every year very long reports? In a way, what we did here is just copy-paste what we used to do for EU candidate countries. So anyway, long story short, where are we now? Essentially, I'm very critical of this mechanism because essentially we end up with non-stop reporting, not presenting a very accurate overview of the situation with non-binding recommendations. And a lot of these recommendations are not complied with. And also the Commission does omit key issues and does omit key recommendations. So it has so many shortcomings. I could spend 2 hours listing them to you. But just to give you a flavor of why it's not working, the main issue from my point of view is that the Commission is in denial about the rule of law issues as they exist for a number of reasons. And just to show you an example of the disconnect between reality and the description adopted by the Commission, what you're seeing on the slide is a paragraph from the press release. Essentially, the Commission has identified a positive trajectory when it comes to the rule of law situation, and essentially, kind of, if you read the press release, you're feeling that the impression you get is that everything is fine. The rule of law situation is improving across the board, and most recommendations are implemented in part or in full. And just have a look at the other side of the slide. Can I have some water? Of course, I haven't had enough water today. Thank you. And this is a gap analysis done by Liberty, a very good gap analysis. So if you have to work on the rule of law report of the Commission, I would say that should be your first critical assessment that you need to look at. Essentially, if you read the transversal report of the Commission and then you compare to the gap analysis, you feel that essentially they're comparing 2 radically different situations. And just to reinforce my point, I'm just going to emphasize the positive trajectory assessment. So you read that in July 2025, positive trajectory. You're assuming that in most member states, the rule of law situation is okay. You would agree? So let's have a look at the assessment of the World Justice Project. So this is a few months after the Commission spoke of a positive trajectory in the EU. So long story short, the great majority of the EU member states saw their rule of law score declined. So on the one hand, we have a positive trajectory. On the other hand, we have most member states whose rule of law assessment, as per this NGO based in Washington, DC, have declined. In fact, the EU this year has two of the countries where the rule of law has declined the most compared to the year before, and that is Slovakia and Hungary. So who's right, who's wrong? For you to decide, I would tend to side with the World Justice Project in terms of the overall assessment of the situation. It gets worse. In purple, I've highlighted a sentence from the press release. Challenges remain in some member states, and in a few cases, the situation is serious. So that's good. I mean, at least this is something a bit more critical. The problem is, I cannot find any trace of this in the actual reports themselves. So I don't know what challenges are. It's not made clear in the actual reports. And the situation is serious. I couldn't find the same phrasing used anywhere in all of the reports. I searched all the reports, couldn't find any indication. So you have serious concerns mentioned somewhere, but you cannot know for sure what is the list of these countries where the situation, a few cases, what does that mean? You cannot get a clear list. I'm moving on because there is quite a few tools left. What you can hear also quite often, the Commission and Council like to present the European semester cycle as something which is rule of law related and playing a positive part in improving the rule of law situation in the EU. Theoretically, technically speaking, the European semester was never designed to address rule of law problems. It was more or less an economic and social coordination mechanism. To some extent, you should compliment the Commission for trying to integrate more and more rule of law considerations into the European semester cycle. Have you ever heard in this room, have you ever come across a European semester document? So perhaps, so essentially, long story short, the Commission does publish a very detailed study about what's happening economically speaking in a specific member state, and has started including developments relating to the national justice systems a couple of years ago. So to that extent, you can say, yes, I mean, that's a positive change. But the problem, in my view, is that they have oversold this mechanism as actually having any impact whatsoever on the rule of law situation on the ground. So you have just an example here of a country-specific recommendation to be found in the European semester chapter or recommendation of the Council regarding Hungary. So each member state, you can find a similar Council recommendation per member state. Not all of the member states will have rule of law issues, so that's okay. But if you read the past few editions of the Council recommendation from the European semester regarding Hungary, it repeats itself over and over again. To make it worse, actually, the Commission is now saying that the Hungarian judicial branch is actually one of the most efficient in Europe. So there is some sort of a cognitive dissonance here with the rule of law being identified as an issue within the framework of other tools, but in the framework of this tool, apparently, the Hungarian justice system is very efficient. Now, why would they say that now, while just mentioning the rule of law in the country-specific recommendation? Because of the Commission unlocking 10.2 billion euros on the back of another instrument under false pretenses. So we're going to park Hungary aside for the moment. My point is the European semester Council recommendations have not played any meaningful part in improving the rule of law situation. For the most problematical member states, you can find some relevant indications of issues However, when there is non-compliance with a Council-specific recommendation in the European semester cycle, no consequences flow, actually. And this is similar to the country-specific recommendations you can find in the annual rule of law report. In fact, they are based on the European semester country-specific recommendations. What's the worst thing which can happen to a member state violating the rule of law in a systemic manner in the context of the European semester? You get a meaningless country-specific recommendation, and then when you violate it, then it gets repeated verbatim the following year. I wanted also to mention the cooperation and verification mechanism, just to give you another example where I would argue that the Commission and the Council have not used the instrument in the best possible way before actually repealing it. I would argue in violation of EU primary law. There is a pending case, but this case has not been assessed on the merits due to legal standing. But long story short, prior to joining the EU, Romania and Bulgaria were subject to a specific ad hoc rule of law mechanism as part of the treaties of accession. And this was a political price to be paid to have unanimity on their membership application. This was a bit unique. It was unique for a long time. It has never worked and actually was repealed just when the Court of Justice started giving legally binding effects to the mechanism itself. But my main point here is that the mechanism was the end of this mechanism was justified on the back of the remarkable rule of law progress made in these two countries. So this is why I wanted to give you a graph just with the rule of law index score of Romania and Bulgaria since they joined the EU, and it has not improved. I mean, I don't know how you understand remarkable, but I don't see any progress myself, so let alone remarkable progress. In fact, it's even worse if you look at judicial independence, especially in Romania. The mechanism was repealed just at the time where the Romanian Constitutional Court was actually openly defying rule of law judgments of the Court of Justice. So legally speaking, the repeal of the CVM cannot be justified objectively. So it has to be justified for other reasons. So CVM, anyway, no longer part of the toolbox, but was repealed, I would say, again, under false pretenses. Now, this is, I'm going to tell you briefly about the recovery rule of law milestones. This is one of the latest additions to the toolbox. So long story short again, we have a post-COVID recovery mechanism. A lot of EU money was made available to help member states overcome the economic impact of COVID-19. And the Commission, rightly or wrongly, decided to use this new instrument to actually help the Commission achieve some rule of law objectives. On paper, I mean, why not? Whatever works would be my default position. The problem in the case of Poland, and again, it's factually a bit complicated, but let's just say that for political reasons, the Commission under von der Leyen and the Polish government at the time could not agree, but then because of political timing, decided to have some sort of a compromise in the form of half-baked, if I can use that expression, rule of law milestones. My main issue from a legal point of view was that at the time I argued, and in fact several commissioners argued as well, that some of these rule of law milestones were actually proactively violating the case law of the Court of Justice. So they were not simply defective, they were actually incompatible with the case law of the Court of Justice. So we had rule of law milestones themselves incompatible with rule of law requirements under EU law. At least that's my argument. You don't have to. I was not the only one with this view. And in fact, two Dutch professors and myself got together, had some beer, maybe not Dutch beer, can't remember what it was, but we decided enough is enough. We're going to sue the Commission and we're going to sue the Council. You can ask me a question about this, which it was complicated strategic litigation because we had to find plaintiffs, but essentially the four plaintiffs we found were four associations of judges. This is the first time in the history of EU law that association of judges got together to sue the EU, not for enacting we should have done that as well, but for actually violating EU rule of law requirements out of political expediency, short-term political reasons. This is known as the Medel case. There was a hearing in the Court of Justice last week. For the time being, the main issue is legal standing. I cannot answer questions about this. But it was nonetheless, no matter the outcome, it was very important to keep the rule of law and the politicization, what I call the politicization of the rule of law in the news. And let's just say that when this litigation is going to be done, I'll be able to write about it. If you had access to the paperwork, as I have, because I work with the legal team, it's, how could I put it diplomatically speaking? Let's just say that EU institutions, what they say to the court and what they say in public do not always coincide. And I go further. I would say there, in some instances, it's borderline contempt of court, in my view. So I would say misleading information may have been provided also. But I will have to write and wait until this litigation is over. But essentially, you get the picture. When it comes to promotion prevention tools, from my point of view, the situation is not healthy at all. We have plenty of reports, plenty of non-binding recommendations, and in the worst cases, the EU itself has become part of the problem rather than part of the solution, leading to judges and prosecutors having to sue the EU in some limited circumstances for violating the rule of law. Now, I'm going to switch to the response tools. And I'm going to let you know briefly, I'm going to give you some critical overview of some of the tools. I cannot really cover them all in details. And I'm going to start with Article 7. I mean, I'm pretty sure being a law student in this room, having done EU law, you must have heard of Article 7 TEU. It was named a long time ago as the EU's nuclear option, but in fact, it has two branches, a preventive branch and a sanction branch. Only the preventive branch of Article 7 has been activated twice in respect of Poland and Hungary. For some strange reasons, the Commission has decided to mention Article 7 in the response tools, but in fact, you should have Article 7 mentioned twice in this overview, because it's what we have activated is a preventive branch, so the one which cannot lead to sanctions as such. It's known as Article 7, Paragraph 1 of the TEU. The procedure against Poland was closed in May 2024. Again, I would argue in violation of the EU treaties, procedurally speaking. I cannot make my case, but you can ask me a question. I had to fight, actually, I had to sue the Commission to get access to the legal reasoning. And there was none. This is why they didn't want to give it to me. So I had to bring a formal annulment action, and I got it 24 hours after I lodged the action. But I'm not going to tell you about this case. You can ask me about this one. So currently, only one member state remains subject to Article 7, Paragraph 1, that is Hungary. And just this slide is one of many examples showing, from my point of view, how the Council has proactively undermined Article 7 procedure. So the Council likes to blame Article 7 for the lack of concrete outcomes, but in fact, this is a good example of self-sabotage by the Council. In my article, I refer to the Council interpretation as one based on the principle of effet inutile. So that's my new argument. I don't know if you have studied EU law, but in EU law, traditional method of interpretation adopted by the court is the so-called principle of effet utile, useful effect in English. So I'm saying that the Council has adopted de facto the opposite method of interpretation. Let's adopt the interpretation of Article 7, which is going to result in the least possibly effective situation. And this is an example. Essentially, we move from in-depth exchanges to up-to-date pictures. So the Council, in fact, not only has the Council not interpreted correctly Article 7, but they have proactively self-sabotage. And now, essentially, Article 7 hearings have just become state-of-play meetings, which is not what Article 7 requires. And I can multiply the examples of poor practices. For instance, just to give you another practical example, the minutes of the formal hearings have become increasingly useless or unhelpful. They used to be relatively lengthy, but as soon as I got access to them, then maybe it's just a pure coincidence, but as soon as I got access to them, thanks to the Finnish presidency, then some people must have got annoyed, and then they shrank by about half, and also they're not publicly available. So every time to get access to the minutes, I have to file a Freedom of Information request. Why are they not publicly available? We're just talking about some member states becoming hybrid autocracies as we speak, but cannot, if there is no public interest in making them automatically available, I don't know then what would we need the situation to be for this to be automatically transparent. Anyway, don't want to get angry, but this is Christmas is around the corner. So one of the key response tools in the toolbox, Article 7, has been essentially, I would say, not properly used. Nothing to do with Article 7 itself, everything to do with the counsel and interpretation of the provision. So whenever you hear criticism of the toolbox, just take a step back. Is the criticism justified, or is the criticism simply used so that you make no effective use of the tool yourself? Infringement actions. There will be a lot to say. This is a graph from an article written by Tommaso Pavone about the rule of law, case law, and the Court of Justice and Commission's leadership when it comes to bringing rule of law infringement actions to the Court of Justice. Long story short, even there is a dramatic gap here between what the Commission says about itself and the dramatic infringement actions it has taken and the reality of the data. The rule of law currently, the real guardian of the treaty, that's my main point, is not the Commission. The real guardians of the treaties are national judges sending preliminary ruling requests to the Court of Justice. 95% of the rule of law, case law of the Court of Justice comes from national courts. You could say, well, that's normal because that's not perhaps unusual, except they're raising systemic issues, which should be raised by the Commission. The Commission's job is to address the system. According to the Commission itself, their job is to raise systemic rule of law issues, not let national judges do so. Why is this problematical from a rule of law backsliding point of view? Every time you have in an authorizing country a national judge sending questions to the Court of Justice, this equates to professional and personal professional suicide with immediate practical consequences on your family life and privacy. I can multiply examples of the price which national judges have had to pay when referring questions to the Court of Justice. A lot of people are aware of what happened to many brave Polish judges, but the situation is particularly dire also when it comes to Romanian judges as well, even though it's less talked about. So, long story short here, and when it comes to infringement actions, we have essentially a total of 5 only infringement actions, all connected to Poland's rule of law crisis. We're going to have the 5th one decided next week with respect of the Polish captured unconstitutional tribunal, as I like to call it. So all of them good infringement actions, even though quite often too little too late. But the point is we could have many more. We should have many more infringement actions. We don't. Rule of law conditionality regulation has been used, yes, I suppose I said half an hour, but it would seem, so give me another 5 long minutes. The rule of law conditionality regulation, again, I could go on and on. As you may know, it has only been activated used once against Hungary, still active. There were indications that the Commission was thinking of using it in respect of Poland, but they only sent 1 letter, then gave up for, as I understand, mostly political reasons, or their own assessment of the best use of the toolbox. What is here, essentially, I'm not going to tell you about my criticism, but I'm going to tell you about the criticism of the Court of Auditors, which is actually quite rare and worth noting. And this is the slide you're looking at is the bottom, the top of the press release of the issue by the Court of Auditors when they adopted a rule of law study. And essentially, their key points is they cannot understand why the rule of law conditionality regulation has been used only in respect of Hungary and not in respect of Poland or other EU member states. Most recently, the EPPO has submitted a formal letter to the Commission requesting the activation of the rule of law conditionality regulation regarding Slovakia. The EPPO did the same regarding Poland in both cases. I'm not aware of the outcome or whether, in fact, the Commission did respond to the EPPO. For the Court of Auditors, the Commission is not able to prove why it has used the conditionality regulation in respect of Hungary and not in respect of countries where similar problems seem to be materializing. And the Court of Auditors, and that this is something worth noting, also diplomatically, but did say that political considerations may affect the use of the toolbox, unsaid political considerations. And the Court of Auditors are also warned against a tick boxing assessment of rule of law reforms, which would lead to EU funding being unfrozen on the back of just purely formal rule of law changes, which actually do not change anything on the ground. This is very much what happened in respect of Hungary when the Commission did unlock funding, but not on the back of the conditionality regulation, but on the back of another tool, which is known as the horizontal enabling condition relating to the Charter. This is the latest addition to the toolbox. Essentially, long story short, the Commission can suspend funding across the board in a situation where the Commission is of the view that one charter right or freedom or several of them are not complied with, or when there are issues relating to the Charter. The Charter, as you may remember, does also include some rule of law based rights and freedom, the right to a fair trial, Article 47 of the Charter. In the case of Hungary, so you had funding suspended on the back of the conditionality regulation and on the back of the horizontal enabling condition, and also rule of law milestones. The situation is quite messy, so messy. In fact, even the Advocate General struggled at the last hearing in this specific case, but essentially, the Commission very controversially unlocked access to previously frozen 10.2 billion euros. Was it December 23, if my memory doesn't fail me. And the Parliament got rightly upset, and in a rare step, the Parliament decided to sue the von der Leyen Commission for unlocking essentially this funding under false pretenses. The argument is that we are, among other arguments, the Parliament has argued before the Court of Justice that this is an example of misuse of power. Essentially, funding was unlocked not because of real judicial reforms being adopted and implemented by the Orban government, but because Orban was engaged in extortion tactics, and the price to be paid for Orban not vetoing the beginning of Ukrainian negotiations with the EU was to unlock 10.2 billion euro. There was a hearing in the Court of Justice last month, and the Advocate General will issue an opinion at the end of February. So same Advocate General actually as in the Medal case, the Croatian Advocate General. But this is rare. And in fact, the European Parliament, you may have forgotten this, has been very good on the rule of law front until recently. Before that, prior to this, the Parliament also launched very rare failure to act action against the von der Leyen Commission when for failure to actually activate the rule of law conditionality regulation. They withdrew the action after the Commission did finally activate the rule of law conditionality regulation against Hungary. Now, from all of this, these are essentially the trends I detail in my paper, and I'm not going to detail them because I have additional examples to justify the identification of these trends, but I'm going through them very quickly. After working on the rule of law toolbox for what is now more than working on rule of law backsliding / toolbox for more than 10 years, 15 years, these are the trends I have identified in this recent paper. And this is a classic trend. Every time there is a new issue, instead of dealing with the issue, we're going to spend time working on a new tool. Then also what I have encountered over and over again is very orthodox, narrow, if not contra-legem interpretations of EU law to justify non-use of timid use of tools. I can multiply the number of examples. Here, one of the worst culprits I have found is the Council Legal Service. They have repeatedly tried their best, not only to justify the narrowest interpretation of the relevant legal tools, but they were also actively sabotaging the Commission 10 years ago to prevent the adoption, essentially, of the pre-Article 7 procedure. I had to sue the Council also regarding access to the Council Legal Service opinion, which regarding the conditionality rule of law regulation. Let me just use the Council to understand what we're talking about here. We're talking about a practice of reverse engineering, where essentially you know what you want to achieve as a legal result, and then you come up with the legal reasoning after. The Council Legal Services didn't want the rule of law conditionality regulation to be very effective for different reasons. So they adopted absurd legal interpretations of the toolbox, didn't want to reveal the legal opinion, in my view, because they knew that it would be subject to harsh criticism from relevant experts. So I had to sue them, and it took me 5 years to get to the end of this. And then the opinion of the Council Legal Service is now public because of this, even though it was widely circulated, and some academics published articles on this opinion, but formally speaking, it was not publicly available until after this litigation was won. And then a more recent trend is increasing politicization, and I can multiply here examples of unhealthy politicization coupled with gaslighting. So essentially what we're seeing is more and more what I call a Panglossian statements. So essentially all is well in the best of all worlds. So, and then you talk to national judges from this legal system and they say, well, what you see in the annual rule of law reports have nothing to do with the reality of the judiciary in my member state. I don't want to depress you further, but the situation is likely to get worse before it gets better because of two new trends I've identified in my paper, what I call increasing reckless disregard for the rule of law in non-backsliding countries. Essentially here, I looked at mostly the situation in Germany and France, but it could be, I think the same framework of analysis could apply to many other member states. So we're talking about non-compliance with judgments, undermining of the very concept of the rule of law, attacks on judges, attacks on courts, attacks on academics, you name it. And then what we're seeing also is increasing lawlessness on the international plane. I mean, I don't need to mention the situation in the US, but in the paper, I mostly take the example of the ICC and the way the EU is failing to react to attacks on ICC and also attacks on ICC judges, even though we've got plenty of tools to actually respond to these attacks. And essentially, at the end of the paper, I make the prediction that essentially, I'm afraid what we are about to witness is simply the tool, what I call the toolbox phase is going to come to an end. And now what we're going to see is non-stop reporting, but with report denying actually the reality of the situation and increasing gaslighting to actually hide the lack of enforcement on the back of reality disconnected reports. And this is the main argument at the end of the paper is this is not simply bad news from the point of view of the rule of law, but this is going to fatally undermine the EU's credibility, legitimacy, and effective functioning of its legal order. But hopefully you can offer counter-arguments to this bleak diagnosis. And if you want to know more about the paper, this is the green and white paper I'm talking about. This is the last paper. So this presentation is based on this paper. But if you want to have a a broader, more descriptive overview of the toolbox from a more kind of in a more neutral perspective. Then this is the EP. You're looking at the EP study I co-authored with Professor Bart. And this is also, I think, possibly a better introduction to the rule of law toolbox, even though it does focus mostly on the annual rule of law cycle. Just to conclude, essentially, the situation is worse than ever. What we have is we have more tools than ever, but possibly we have wrongly focused on creating new tools rather than using the ones we had more effectively, more quickly, and then on a more sustained basis. Happy to answer a question at this stage. Thank you.
Thank you.